Hello and welcome tonight to our program, which is, the live exam prep series here at the Institute of Real Estate Education. We have a lot of fun with these programs because we just dive right into the things that you're going to have to be faced with someday when you're face to face with a computer trying to get a C minus on a licensing prep exam or a licensing exam. So, you can do this, folks. We've been getting a lot of, I started this business in 1978. We were in kind of a recession. It was not a good time. Interest rates were 10 and a half. First interest rate I ever had on a house loan was 10% or 10 and a half, something like that. And I thought, wow, what a bargain. Um, so high rates, low rates, great markets, slower markets, buyers markets, sellers markets. I don't care. Any market is a realtor market, okay? Because we just take our percentage off the top. Now, all this stuff about, buyer's agent, seller's agent, we're lucky here in Utah is that we're way ahead of the curve on that because we've been using buyer contracts in our state for years and years and years and years. Okay, some states have never even seen a buyer's contract, and they don't, well, which way? You mean the buyer has to sign a contract? Yeah, and so a lot of things, there's only one constant in our industry, and that is change. But tonight, we're going to be talking about some questions that you're going to see on the general exam. Most exams have a state portion and a national portion. Tonight, we'll be dealing on national topics. And so with us tonight is Dan Naylor, the owner of the Institute of Real Estate Education and our techno genius for tonight. So welcome, Dan. Dan will actually be behind the scenes operating all the slides and all the tech stuff. Because as you can tell by the color of my mustache, I missed all that. Well, anyway, let's go to number one, please. Okay. Number one, and the first question we'll be looking at tonight is that an agent commission is determined by. All right. So we don't do this for free. This is our industry. This is our job. This is what we do for a living. And we only get paid when we make a sale and you make a commission on that sale. But an agent commission, how much do you get? What is it determined? Is it determined in the purchase contract? Is it determined in the listing agreement? Is it determined in negotiation between the buyer and the seller, or is it determined by state law? Well, state law you can throw out. The state's not going to have a law that says thou shalt always get 9% on everything that you sell. That's just not the function of the laws at all in virtually any state. So throw out deep. All right, now we got a 1 out of 3. Negotiation between the buyer and the seller. Okay. Well, not really. Because the buyer and the seller, although both of them are going to have to agree now to some commission issues, it's not a negotiation between that buyer and that seller. It's a negotiation between the seller and their agent and the buyer and their agent. So throw that one out. So now we got a 50-50 chance. Do you think it would be in the purchase agreement, which is an agreement that only deals with the buyer and seller, or do you think it would be in the listing agreement, which would be an agreement between the seller and their agent, or the listing agreement between the buyer and their agent? Well, obviously this one is B, the listing agreement. And if you're heading from that direction, hey, your instincts are great. If you're heading to the purchase agreement, the agents aren't really part of the purchase agreement. The only thing that we might have a minor role in is collecting the earnest money and maybe signing for its receipt. But other than that, the purchase agreement is between the buyer and the seller. The agents aren't involved. The listing agreement, whether it's a buyer's listing or a seller's listing, is what you need to look at here. Let's go to number 2, please.
Hey, hope you're enjoying the video. Be sure to like and subscribe so you don't miss any more of them. And if you want even more review material, we have in the PrepMyExam link in the comments. We've got a plethora of practice exams. We have audiobooks. We have an exam simulator. We have everything that our students use to pass the exam on their first try. Okay? And if you want to get licensed in Utah, check out realestateonlinelearning.com and we'll hook you up.
All right, here we have a person named F. And they're signing a listing agreement with their agent. F is married, but the property's in F's name only. Okay, that's fine. Even though you live in a community property state like California or Arizona or, New Mexico or Idaho, any of those community properties stay. That's great, I mean, but you could have community property, in other words, owned by the marriage partners together, whether you're on title or not. But you can also have separate properties as well, and there's rules for that, and um, the largest number of absentee owners in the state of Utah, just for your knowledge, the largest number of people that live somewhere else, live in a different state, but yet own property here in Utah is California, of course. Now, sometimes it jumps back and forth between California and Idaho, but I mean, California far outstrips it as the number one place where people live and own property in Utah. Okay, now I bring that up because um, California is a community property state, and so is Idaho, and so is Arizona, and several other states. Well, how can you tell? Well, they either have French or they have Spanish origins. And now, obviously, all these Western states at one time, were part of Mexico. And of course, and there's some, there's a few like Wisconsin voted it in, but primarily it was the Spanish origin, which those are customs that did that. So F has a property. He's married, says so right in this first sentence here, right? And but it's in F's name only. Okay, so they did not have the spouse sign a listing agreement. Okay, well, why would they? She's not on title. The agent is planning to show the property while F is out of town on business for a month, and they're unsure when the property will sell, so they made the listing agreement for an undetermined length of time. The commission will be based on a percentage of the sales price minus a discount that the agent agreed to with F. So what's wrong with this arrangement? Well, okay. Putting aside all that stuff about, buyers listings and sellers listings for a moment, let's look at A. Agents cannot offer discounts to sellers. Well, sure they can. You can offer discounts to sellers. You can offer discounts to buyers too. B. F should have had the spouse sign a listing agreement. Well, when you're going out on a listing appointment, you need to do some research and find out who's vested in title. Because there could be situations where you have majority owners that own, let's say, 75%. There's two of those. And then you have one minority owner who owns 25%. Well, majority rules, right? So you should only have to have those first two signed. No, if anyone's vested in that property, whether it's even a 5% or 10% or what, regardless what the percentage of ownership is, all owners have to sign the listing contract. Okay. So should have had their spouse sign the agreement? Not really, because he or she, whichever F is and whatever they are, they they're not invested in title. See, a listing agreement cannot be for an undetermined length of time. It must have a definite expiration date. It must have an expiration. Okay. Well, that one's it. That's the correct answer here, guys. Or let's look at D. An agent cannot show a property when the owner's out of town. That's when you're needed most to show the property, when there's nobody else to show them through. And a lot of times, I mentioned California and Idaho and some of those other states. You know that you can actually have your friendly title company help you pull together a list of people that live out of state but actually own property here in Utah. Now, why would you want that? Well, what if you were driving through a neighborhood and you saw a vacant property and the lawn's all yellow and dead and I'm not in good shape at all. You say, oh wow, so you pull over, you get out of your car. There's two pedals in there. Usually there's the clutch and and some that would make it three, but there's a brake and an accelerator on the other ones, mostly automatics. So what happens is you hit the brake and you get out, you go knock on the door, and nobody answers. You kind of peek in the window just a tiny bit, because there's blinds are open or whatever. And I don't get to the point where you're suspicious looking and the neighbors call the cops. That could be embarrassing, but hey, you have a realtor license. And the cops know that that we don't here in Utah, we don't license people that are scummy. So we just don't. So, let's look at number 3 now. Okay. It's enough talk about this one. All right. Number 3, in order to determine which form of ownership to take, when purchasing a property, the agent should advise the buyer. Ooh, I don't like that word advise, yeah, we're licensed to sell properties, but I'm not sure that, a lot of the things we do, could kind of borderline giving advice, or at least you're showing them different things. And maybe you're doing some pro formas if you're doing commercial real estate and you've done some market studies. That's all fine. But advising someone on how they should be vested and entitled, I mean, you really don't know. Here's this great couple. They're they seem to be getting along very well. They're married. It's little kids, and everyone's calling everyone mommy and daddy, and this is great. And so they say, well, how would you advise us to be vested and entitled? Well, nice little married couples like you with all these beautiful children, normally they would probably want to be joint tenants with full rights of survivorship. Okay. Well, heck, that's giving legal advice. What you did not know was those were not his kids. They are now because he's stepdad, but they're not his natural children. And what you also didn't know is that the money for the down payment on this house they're buying for their new family came from the insurance proceeds of her first husband, who was the father. Now, if you advise them to take joint tenants full rights survivorship and something happens to her, it's his property. And who gets upset about this? Grandma and grandpa, when, their ex-son-in-law brings the kids home to grandma and grandpa and says, here, you take care of these kids. Well, what about the house? Oh, that's all mine. Why? Because it was a joint tenant full rights survivorship. So upon death, all you need to do to prove that up is record the death certificate in the property in the state in which the property is located. That's all you need to do. It's automatically his. So, all right, let's see. All right, the agent should advise that the ownership is determined by the broker. Oh, heavens no. That the title will list the options available. The title? No, the title is a history of the ownership. To consult their broker, or like your boss, or maybe you are the boss, maybe you are the broker. To consult an attorney. Now, all these, the ones should just pop out and and be this beautiful color. It's like in our instance, it's brown, but to consult an attorney. Yes, why? Because only an attorney would ask them the right questions, like, well, now, so are these all your natural children? No, that's her natural children, and none of these kids are mine. They are mine now. I claim them, but they're not physically mine, biologically. Consult an attorney. If someone wants legal advice on how they should be structured to buy a property, a lot of people might even consider not even having it in their name at all. They may want it in a trust, so that it would be a little bit more protected, not only against their foolishness, but also against other people that are trying to, maybe they felt they were harmed by this person, and they're seeking a lawyer to help them sue you, and the lawyer is going to do a asset search. And why they do an asset search? Because should they win this case, they want to collect, and so they can only collect from their client, or they can collect from maybe the other party, and a lot of that depends on the judge they get, but still, they should be talking to an attorney for all those types of issues. Hey, we're salespeople, okay? And I love now in Utah, you must represent someone. This little deviation into Utah law, but you must represent either the buyer or the seller or both. Some states, a lot of our neighbors, Colorado, Florida, a few others, have actually come to the point now where you can just declare that hey, look, I'm just an agent. I'm just a salesman. Okay, if you want representation, if you want a fiduciary to actually work with you on this transaction, I can recommend several different attorneys that you should talk to. Let's go to number 4, please. Number 4 says a buyer purchases a very unique property. I don't know, geodesic dome. I don't know, maybe it's on a cliff. But a buyer purchases very unique property, and they're worried about acts of nature or other unknown events that might damage and lower the value of the property. What should you advise them to do? Well, get a home warranty that lasts for a whole year, and if your dishwasher breaks and they come out and they fix it. If they can't find parts, they buy you a new one, because there's just no parts for the old one. Okay. That's all the home warranty does. It has to be renewed every year. And that's what it's for. Consult with the broker. I get a tickle out of that one because, most brokers are very busy. And now in our state of Utah, they've allowed brokers to have as many agents as they want. So, that would be a legitimate question. How many agents here are at the firm? They say, well, 350. Yeah, right. So how much time do you think you're going to get with your broker? That's okay. They probably have a sales manager and other trainers that'll work with you. See, consult an insurance agent for advice. Ooh, that one sounds warm and fuzzy. I mean, who would you want to talk to about things that acts of nature or other things that could possibly damage the house? And, could you get coverage for that? Well, that'd be an insurance agent. P, put up a fence around the property. Yeah, right. That's going to really protect you against a big windstorm or a hailstorm or, a mudslide or any other numbers of things. We're all watching for the big earthquake here in Utah. It hasn't happened yet, but we'll see. So out of all these, the correct answer for number 5 is C, consult an insurance agent for advice. A great insurance agent should be on your team. A great inspector should be on your team. There's a great lender should be on your team. A great title company should be on your team. And what I mean by that is you can get help from all these people in your marketing efforts. And you need to have good ones that you can refer people to. Let's go to number 5, please. Oh, here we go. All right, when a sales agent is showing a property to their buyer client, so whose client are they? I guess it's the sales agents, right? Because it says their buyer client. And they notice an encroachment on the property. What should they advise the buyer? Now, an encroachment, if you remember all your terms, and a lot of getting through the exam is knowing these terms. I mean, if you fall asleep during the vocab portion of any of the classes, you're gonna have to take that sucker again because these are not words that we use a lot. I mean, talking with friends, do you say, well, don't encroach? Yeah, okay. Hey, you're getting too close. Don't encroach in my personal space. Yeah, we just don't use words like encroachment that much. But if you notice one, because an encroachment is an illegal trespass on someone else's property. A, you require the encroachment be removed before closing? Maybe. B, not to submit an offer on the property because of that horrible encroachment. Well, maybe you can work around it one way or another. C, consult an attorney before making an offer on the property. Leave the property immediately. Yeah, there could be germs or something from this encroachment. I don't think so. All right, out of all these guys, you can eliminate D, okay? C, I don't know, man. That sounds really warm and fuzzy to me. B, not to submit an offer on the property. Hey, maybe it's the perfect property. There's just a little encroachment problem that needs to be addressed. And maybe it could be very simply addressed, like maybe moving a fence or something. No big deal, maybe. Okay, but anyway, if it's their property, to tell them, well, let's go find something else. They'll chuck you and go find another agent who'll help them get that property. That's what they want. But just make sure they're informed about what they're getting. So obviously, who they should be talking to about this type of issue would be an attorney. And a lot of times the title companies have an attorney on staff. Sometimes they don't, but sometimes they do, or they could recommend their attorney that to give more information. But a lot of title companies will sit down and talk to your buyers about the ramifications of an encroachment and then recommend they go talk to their in-house attorney, or maybe they are an attorney. One of the title companies that I use, they are attorneys. Okay, let's look at 6. Number 6, here we go. Okay, a real estate agent submits, oh, yeah, that's C is the correct answer. A real estate agent, number 6, submits their client's offer to the seller. Cool. Seller calls back with some concerns. The agent negotiates with the seller on behalf of their client. The seller signs a counteroffer and the agent signs the offer, accepts it on behalf of their client. Then they send the completed contract to their broker. Which of these actions was improper? Well, guys, obviously it's accepting an offer on behalf of the client. I mean, you can't do that. Sending a contract to their broker? Well, yeah, you send all your contracts to your broker, depending on what the policy is in your company. But yeah, your broker broker's supposed to know everything that's going on. And sometimes they want to review something, and maybe they ask you to rewrite it, or they say, we have an addendum you should use with this. So sending it to your broker is not a bad thing at all, but if they have 350 agents, that may take them a little while to get back to you. Negotiating with the seller on behalf of the client, hey, we do that sometimes. I mean, submitting an offer to the seller, sending it to the seller, well, yeah, that's not bad. The only thing that's really bad here is thinking you can accept an offer on behalf of the client. Now, if the client had given you their power of attorney, then I guess you could sign it for them. But most brokers will not let you do that. Well, why? Well, okay, here's my, here's my situation. Okay, I got this offer. If in my seller's given me their power of attorney, if I sign it, I make a commission. Now, is that a conflict of interest? Yeah. If I don't sign it, I don't make a commission. So most brokers won't allow you to have a power of attorney to sign for the principals. It doesn't make sense. That should go to someone else that they know and trust better. I mean, it could be your brother, I guess, and you could be the agent still. I don't know. I mean, but most brokers don't want you to have that kind of authority because it's inappropriate. It's just inappropriate. There's conflict of interest there. So be very careful of that. I mean, your broker will monitor and help you through some of these things. Or if they're uh, running 350 agents, I'm sure they have a lot of middle management that could actually help you as well. All right, we're on number 7. Number 7, one of my favorites. A real estate agent closes a deal. Yes, yes, I love it when you close a deal. And the buyer is from out of country and cannot attend the closing. What should the agent do? Attend the closing and sign on behalf of the buyer. Well, that, I refer you back to my previous discussion. That's conflict of interest, really. I mean, make a commission, don't make a commission, make a commission. I think I'll make a commission. Advise the buyer to have an attorney draft a limited power of attorney. Okay. Kind of like that one, guys. See, get errors and omissions insurance. Well, as an agent, you don't get errors and omissions insurance. It's something your broker normally does. And smaller mid-sized firms, a lot of them do get errors and omissions insurance, and there's an errors and omissions insurance charge that's paid to the office to help offset that. But a lot of the bigger companies, that have hundreds and hundreds of agents, a lot of them are self-insured, and so that money that you pay goes into a fund that they keep, and after a while you got a few $1,000,000 in there, and that then you can avoid the errors and omissions insurance because you're self-insured. D, create an addendum to the purchase contract that allows the agent to sign for the buyer. Yeah, no, I don't know. Yeah. All right. So this is number 7, and the correct answer, guys, is B. I mean, you knew that. Advise the buyer to have an attorney draft a limited power of attorney and put someone that they trust, like their brother, their uncle, their lawyer, to sign for them, their mom, their dad, whatever. Someone who loves them, it's conflict of interest for you to be that person. And if it is your brother, I sold my brother's house. Actually, we had a hard time getting it sold. It was a very quiet time in the market, so I just bought it. But boy, he had to sign lots of disclosures. Okay, number 8. Number 8 says, how long must lead-based paint disclosures be kept by the broker? 3, 5, 2, or 1 year? Well, 1 year sounds a little short. 2 years sounds a little short. 5 years sounds a little long. So, the Cinderella thing here is A is just right. Okay. Is that Cinderella? I think it was. Okay. All right. A is 3 years, and that's the correct answer. Lead-based paint disclosures have to be kept for 3 years. Now, please, I'm just admonishing you. As an agent, keep your own files. I mean, yes, your broker has a copy of everything, and they may even want the originals. That's fine. But you need to keep your own records. Well, why? Well, who's to say your broker's going to be around that long? I mean, you never know. I worked for a broker. I was their number one agent in the office. And she and her husband got divorced, and she packed up and moved to Portland. you know, well, all right. So I needed to know where the records would be kept. I mean, the division has to know. She has to let them know within 10 days, but of closing the firm. But I I keep all my own records. In fact, I've got a whole box of them in the back of the car I got to have shredded here. But how long must the lead-based paint disclosures be kept, guys? 3 years. 3 years. 3 years. You know, a lot of these questions, oh gosh, the test is so hard. Well, if you don't know the answer, yeah, it's going to be really hard. It's 3 years. 1 and 2, too short. 5, too long. 3 years is just right. Let's look at number 9, please. A reserve fund is often included in a management contract to allow the manager to do stuff. Okay, well, to do what? A, pay for small repairs on the property. Okay, pay for large renovations. C, collect a commission on leases, or D, construct additions to the property. Well, I like C because it talks about commissions, and I like to make commissions on leases. They're great. I've done a lot of that. You do that when you're doing commercial leasing. But really, guys, the correct answer here is not, it has nothing to do with your commission. It's not to pay for large renovations, and it's not to construct additions. It's to pay small repairs on the property. If you're a property manager and the tenant calls and says, "Oh my goodness, the water heater, something's wrong. It's leaking all over the floor," and you get out there and um, you hopefully you have a plumber you can call to get them out there, and it's going to be $1,200 or something and put in a new water heater. That's what this fund is for. If you're managing a 25 unit, a 30 unit, a 120 unit, even a fourplex, you need to have some sort of emergency repair funds because they're not going to go without hot water. And you can get a plumber out there throwing a new water heater. It's going to be around 1,000, $1,200, something like that. But still, it's a fund to pay for these small repairs. You just need to have that. I mean, if you're managing 12 or 14 units for someone, and some of those are fourplexes, some of those are duplexes, you got a lot of units, and you should have, a reserve fund that is in proportion to emergency repairs, so you can get in there and get it done quickly without coming out of your own pocket. I mean, why should you have to come out of your pockets? It's their property. Oh, that makes a lot of sense. Okay, good. And then you remember that's what it's for. Reserve fund is to pay for small repairs. Number 10, if a property manager believes that there might be a trip hazard where the floor inside a unit is uneven, who should they inform? A, the owner only. B, the owner and all prospective tenants. C, their broker only. Or D, the broker and the owner. Okay. Out of all these, A's limiting, C's limiting, D's limiting. Hey, this is a trip hazard, okay? Anyone, it's even prospective tenants that are going to come through the property, say, hey, watch out, we got a trip hazard here. I don't want you to get hurt, but we will get that repaired prior to occupancy, but it's not repaired today. All right, 10, if a property owner believes that, and then it's B, the owner and all prospective tenants. We want everyone to be safe in that property, even if they choose not to rent it, or you choose not to rent to them. Number 11, please. All right, number 11 says, when a tenant remains in a property after the lease has expired, how do we refer to them? Are they a tenant in common, tenancy, a tenant by entirety, a holdover tenant, or an encroaching tenant? Okay. An encroaching tenant, well, you're encroaching. Well, no, that's a wrong use of the word encroaching. The correct answer here, folks, is obviously you're a holdover tenant because, you were a tenant, but now you're a holdover tenant because your tenancy agreement has expired. So you either get that renewed or get out. Yeah, so you can work something out. I mean, sometimes people who are building a big, new, beautiful custom home, they don't sell their old home, before they buy before the new home is finished. A lot of times they get it all built and then they just move from the old home into the new home and then you put the old home up for sale. Okay. Um, but a lot of times if you have a tenant in there, they're not necessarily the owner. Maybe they need additional time, whatever. And you can sit down with them and renegotiate. Well, our new home is not quite ready for us. So, we need another 2 weeks in order for us to, make the simple move from here to there. We don't want to move our stuff into storage and whatnot. So, working with your tenant, maybe they've been a long-term tenant and a great tenant and whatnot, but they're a holdover tenant. So they do have some rights, but they don't have all the same rights they had because their agreement is expired. But they're definitely a holdover tenant. They're not a tenancy by entirety. Yeah, that's one of the ownership classes where you have to be legally and lawfully married. You're not a tenant in common. Uh, tenant in common. Uh, you can have varying percentages of ownership there, and they're not an encroaching tenant. That's just you know, a bad answer. Number 12, please. Okay, number 12, S signs a lease for a strip mall located for their business. A little strip mall, usually they're a one-story type thing. Sometimes 6 or 8 people are in there, you know, different businesses. They expect the sales to be low at first and then increase as they build their presence in the area. They negotiate lower rent payments as the beginning of the lease. Okay. With the rent payments steadily increasing over time. So is it an escalator? Is it a balloon? Is it an advancing lease? Or is it tenant in sufferance? Okay. Well, a tenant in sufferance might be a tenant that's either violating their agreement or their agreement has expired. And that's not the situation here. Um, they're just moving into the strip mall and they're going to build their business there. And so they want to pay a little less now, a little more later. An advancing lease, well, it does escalate, but that's not the term used here. So I don't know what an advancing lease is. I mean, is this something that's moving forward? A balloon payment. Balloon payment is any payment in a loan that is in excess of the normal periodic payments. So if you had $1,200 a month periodic payments, and at the end of your agreement to pay that note off, there's a balloon payment of $20,000, $30,000. A balloon payment is any payment that's higher than the normal periodic payments. So really what we're looking at here is an escalator. Escalator can take people up or down. In this case, we're going to be going up because the rents are going to be going up. Okay. So you get on the escalator and you go to the top, and at the bottom, your rent may have been $1,200, but the top, maybe $1,800. Maybe it increases a couple of times during the lease period or more. Okay. It's an escalation clause, escalator clause. Very common, actually. Number 13. Number 13 says a new business is opening and they want to get a lease that is lower rent in the beginning, and they will increase their sales as uh, as their sales increase, they'll increase their rent. What type of lease is this? Well, kind of one way of doing that is particularly in retail. Okay, is you use a percentage lease. And that's the correct answer here. It's not a gross lease. A gross lease means that all of the money you pay, the landlord pays all the expenses. A net lease is a lease where the landlord gets a check and it's all net. The tenant pays all the expenses. Package lease is where you're renting both real and personal real estate. I mean, a real and personal property. It's a kind of a package together. A lot of our condos and a lot of our homes in Park City are have a package lease on them where you go in and you or an Airbnb property, it's fully finished or fully furnished, excuse me. And what happens, that would be you're renting the money you pay pays for both real and personal property usage. So guys, a percentage lease would be the way to go, because yeah, you're paying a base rent, but as your business increases, you're paying more on a percentage rent. Now, what they do, practically speaking, on these percentage leases is they have the right to look at tax returns. And they figure most people don't fudge or lie under tax returns because it's a criminal offense. Um, so they could see what your income actually was, and then they get their proper percentage of that. Very common in malls, very common in any type of building. Really, it could be a warehouse, it could be an office or a medical space. But you're starting out, and if you can get a little help with a little smaller monthly outflow until you get your business going, that would be good. And landlords have to look at this and say, well, would I be better off having a tenant and giving him a break in front and then collecting more later, or am I going to just leave it vacant? I mean, you have to make a decision. So the other thing is a lot of times you have a particular type of business that you want in that strip mall because you want the proper mix. Like you don't want two pizza eatery places because they compete with each other. That you want maybe one restaurant, but you may want there are complementary type businesses that would actually help each other, and so you want a good blend, a good mix of tenants. Number 14, please. Real estate's so fun. There's so many different ways you could take your career. You could jump right into commercial, or you could just do residential, you could do multifamily, all kinds of things. You could just do straight leasing. If a landlord fails to maintain a property in livable condition and the tenants are forced to move out for safety reason, what is that called? The landlord's prerogative. Immunity, foreclosure. Well, all those are great terms, but they don't apply here. It's constructive eviction, D, constructive eviction. It's not a foreclosure. That's what banks do when they're trying to collect on their note. It's not immunity. That's what you get for testifying. and because you testified, you get a smaller prison term, or you get no prison term. Landlord's prerogative. Okay, all right. Sounds important. It's not. It's constructive eviction. You will see this on the test. So, uh, how do you give constructive notice? You record something in the public record, but this is a little different here. If the property's not safe, I mean, if maybe they filmed some things, and maybe they have kept records of how many times they've emailed you or contacted you by phone, begging you to get out here and fix the problem, and you don't get it fixed, and you just pack up and book out of there. I mean, they're not going to live with cold water. They want a water heater. you know, and a lot of commercial leases, a lot of them are net, and the tenant pays all the expenses. Well, why is that an advantage to the tenant? Because the tenant maybe wants to have a beautiful property, and the landlord's idea of beauty is to throw in a couple of dying shrubs. But the you know but you want the business to reflect the quality of your business and the quality of your service or the quality of your products. So you want it to be absolutely gorgeous. Okay. Well, then the landlord says, well, fine, we'll just do a net lease. You just pay me this much money and you pay all the expenses, but you have to maintain the standard. In fact, they would probably go beyond that standard. Let's look at 15, please. There's a lot of solutions, and it's really cool. The brokers we have in Utah are quite adept at helping you. Uh, and a lot of times they have trainers and other staff too that are there to help you as well. Well, looking at number 15, a tenant leases a property as is. During the lease, the furnace quits working, the front siding becomes damaged, the paint gets severely weathered, and the roof starts to leak. Whoa, yeah. Okay, this needs a little bit of deferred maintenance taken care of. Okay. So, what are the landlord's responsibilities? Well, let's look at A. A says there is no as is lease. The landlord's responsible for everything. No, that's not true. I just gave you some examples of commercial rentals where the tenant is responsible for everything. And maybe that's the tenant's advantage because he wants it to be primo deluxe. That reflects on their business. I mean, if you were always calling the landlord, say, would you get some prettier flowers out here, or the paint's peeling, or, I got a leaking roof. My son is a chiropractic physician, and the roof in the building I put him in is leaked the whole time he's been there, but he doesn't care that much because it's just one of his back offices. But he's been after the landlord to fix it forever. And I know the landlord's a great guy, but he's just not used to fixing things. Okay. But there is no as-is lease landlord responsible for repairs. No, that's not true at all. It's called a net lease. B, in an as-is lease, the landlord would only be responsible for the roof and the furnace to maintain livability. Yes, I kind of like that because the landlord has, if it's something they're living in, I mean, it's not a retail type space. It's an apartment. Okay, then the landlord has, basic concept of law, to maintain livability, and so there wouldn't be an as-is type thing. The as-is is probably more in warehousing, that type of thing, commercial stuff. See, the landlord must notify the tenant for the damage is unacceptable and the lease is terminated. Well, okay, sounds pretty definite, but that's not the right answer. The right answer, like I said, well, I maybe haven't said yet, but look at D. The landlord has no responsibility for repairs in an as-is lease. Look at B. Look at it very carefully because that is the correct answer. In an as-is lease, the landlord would only be responsible for the roof, the furnace, and to maintain livability. And if you're thinking about an apartment, maybe that makes a lot of sense to you. Well, hey, I mean, how can I live here if the furnace doesn't work, the water's leaking all the time, and the roof, it's seen better days. Well, number 16, please. One of my favorites, a property management contract should include each of these items. Property description. People need to agree on what they're actually managing. Term of the contract. Ooh, that's good. The manager's responsibilities and a manager's authority, reporting requirements, and terms of compensation, a lease, power of attorney, a budget for incentivizing tenants. Well, out of all these things, guys, what do you think? Very basic definition here, but obviously, guys, it's going to be terms of compensation. Okay. Not a power of attorney, not a lease, and not a budget for incentivizing tenant. Okay, not that either. Okay, it is the terms of compensation. So there's no confusion. And number 17. Now, number 17 is a property management agreement should be signed by whom? Well, the tenants and the manager. The owner and the tenants. Now, what are we talking about here? Are we talking about the tenant agreement or is it the property management agreement? Well, if it's a property management agreement, that's agreement between the owner and the broker, or the manager, the tenant and the manager, the owner and the tenants. How about the tenants and the broker? No, no, no. Obviously, it's going to be D, the owner and the manager. This is what I will do. This is what I'm not going to do. This is the authority I have, and this is authority I don't have. And here's how I'm going to be compensated. I mean, a very straightforward agreement. When I was doing a lot of commercial leasing in the big, business type office buildings I used to rent, like in Union Park and whatnot, we would have our standard lease, and the tenant would come in. They'd be very interested, so we do a floor plan drawing to show how we could build that space out to work for them, and they get all excited about that. And then we get down to the agreements, and we would hand them our standard agreement, and they would hand us their standard agreement. The tenant have standard agreement. I mean, we have these big national tenants and they all have standard agreements. Okay. Well, we have a standard agreement for our building as well. So the lawyers get together and they work out a new standard that everyone's happy with. Okay. So, a lot of ways you could go on our business. Have enjoyed being with you tonight. We have a series of these and, you're welcome to, use them any way that you can. We want you to pass the exam, and we want you to pass the exam the first time. And if you watch enough of these videos where we actually dig into problems, I think you'll find it very, very helpful, and that our live exam prep series might be the very thing that gets you through the test. Thanks for being with us tonight. This is Rick Roller. Thank you, Dan Naylor, and the Institute of Real Estate Education, located here along the Wasatch Front in the beautiful state of Utah. See you out there. And if you need help, don't hesitate to call.
Thanks for watching. If you want to show some appreciation to our instructors, be sure to like and subscribe so that they see how much you enjoyed it. And if you want any additional review material, check the links below for our full suite of practice materials for the real estate license exam. Thank you.